Happy Monday, everyone. Welcome back to the channel. Thank you for tuning in. You're watching the VSO Gun Channel. And today, we're talking about the Supreme Court again. I'm sure that at this juncture in the day, y'all have seen something somewhere about this whole sensitive places concealed carry restriction case. If you haven't heard about it recently, then you've at least heard about it before. Basically, this is a case out of the state of Hawaii, and the state of Hawaii is in open rebellion against the Supreme Court. And we were kind of hoping that we were going to get the Supreme Court to take this case, but they have decided to deny certiorari. And I think there are a lot of people commentating about this on the internet that are turning it into something that it is not. And this, simply put, if you read the document, is an affirmation that the state of Hawaii is in open defiance of the Supreme Court's order, its jurisprudence on the Second Amendment. The Supreme Court recognizes that. This is a 7-page document penned by Justice Thomas. However, this case is in what is known as interlocutory posture. That's a fancy way of saying that it is not the Supreme Court's turn yet. So even though the Supreme Court recognizes that the state of Hawaii is doing something that is extra constitutional, that they're not allowed to do, the Supreme Court cannot at this point step in because it is not their jurisdiction to do so yet, because the lower courts have not finished their work yet. All this said, correction to the Hawaii Supreme Court's error must await another day. Wilson moved to dismiss only some of his charges, most notably leaving for trial a trespassing charge on which his Second Amendment defense has no bearing. He thus seeks review of an interlocutory order over which we may not have jurisdiction. I agree with the court's decision to deny certiorari in this posture. In an appropriate case, however, we should make clear that Americans are always free to invoke the Second Amendment as defense against unconstitutional firearms licensing schemes. Perhaps Wilson himself will present that case should he file a post-trial petition for certiorari. Regardless, this issue is an important recurring one, and this court's intervention clearly remains imperative given lower courts' continued insistence on treating the Second Amendment right so cavalierly. So, in other words, come back later after you got all your stuff together and it's actually our turn. Now, I understand where people are coming from with the doomsaying. Basically, we've gotten two pieces of bad news from the Supreme Court in as many weeks, and I can see why people are saying what they're saying about this, but I think there's a clear difference between what happened here and what happened in the Vanderstock case. I clearly do not agree with the decision in the Vanderstock case, and in my opinion, it is inconsistent with what the Supreme Court has said previously. And to distill that down to a couple sentences, in the Vanderstock case, the Supreme Court basically said, hey, the executive branch can rewrite definitions that Congress has passed. And I don't see how that hunts at all. I don't see how that is constitutional whatsoever. But you know what? I'm not a Supreme Court justice. Now, there's a substantive difference between what they did there, which in my opinion is just flat out wrong, and what they did here, because the Supreme Court has, for a long time, been pretty shy about doing stuff out of turn. There's been so many laws that have been written from the bench, so much legislation that has been made from the bench, so to speak. Just look at like Roe v. Wade and all that sort of stuff, that the Supreme Court is very hesitant to do anything that isn't quite their turn yet. So you can probably count on one hand the number of things that they have taken in an interlocutory posture in the last year or so. Very few. Today's video is brought to you by XS Sites. I'm out here today preaching the good word of the XS Big Dot site. If you don't like the XS Big Dot site, then you're wrong. No, I'm just kidding. I started using the big dots because I took a low light force on force class. If you've never had that experience, I could totally see why somebody wouldn't select that site, but it is my go-to site. They offer a whole bunch of other things out there, and XS has been a big time, long time supporter of the channel. So I very much appreciate them supporting the mission here at the VSO Gun Channel. Let's get into the video. Now I look at this as a double-edged sword. The bad news is this kind of crap is going to continue. We're going to continue to see infringements like this from all the locales that you know, that you can name off the top of your head, that do this kind of crap. They're going to continue to do the sensitive places thing, and they're going to just continue to label as many things sensitive as they possibly can. Even though the Supreme Court has said that you can't do that, they're going to continue to do it until the Supreme Court finally takes a case. And it's going to take, as they've said here, a case that shows up in the correct posture. So one that has gone through final judgment at all the previous levels and is ripe for review of the Supreme Court. That is what is going to have that is what is going to have to take place for the Supreme Court to actually rule on it. Now, the other side of that is that they have flat out said that if you come back here and give us an opportunity to do so, when it is actually our turn, we're going to smack you, and we're going to smack you big. But here's the thing about that. I don't think that that is actually going to deter anything. It might lawfully stop, once that happens, it might lawfully stop that kind of behavior from occurring at the state level. But until somebody somewhere starts prosecuting these officials under like color of law or something like that for violating people's civil rights. Because the bottom line is that there are going to be activists in government no matter what you do. Like, they're going to be there. But until you start actual consequences for this kind of behavior, it's not going to stop. Because you can say, oh yeah, well, we stopped them from doing X, Y, or Z, or, you know, whatever, this time around, but that's not going to stop them the next time. The only thing that's going to stop them the next time is the prospect of actual consequences. So I've called on this administration that is here right now. If they want to be a friend of the Second Amendment, what they ought to do is they ought to go to those locales and say, you official in New York, you official in Hawaii, et cetera, et cetera, et cetera, name them. You are violating people's civil rights. And for that, we are going to charge you. And if convicted, we are going to throw you in prison. Y'all seen what happens when those people get arrested, you know, the same type of people that are out there keying the Teslas and stuff like that. Yeah, they claim up pretty hard. Anyway, that's what I got for you guys today. Let me know what you think about this in the comment section down below. Unfortunate, but it totally foreseeable, to be honest. In order to meet length requirements, I need to add an extra 15 seconds to this video. So if you guys have any ideas for topics that you would like to see discussed, then sound off in the comment section down below. I will do my best to get to them. Remember, y'all have many more eyes than I do. Thank you very much.